What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to break down the hearing that happened this morning in Karen Reed's case, where the judge handed out a lashing to the defense team, about as strong of one as you can hear in court. But what followed was almost even more interesting. And we're going to talk about how that's going to affect the case, if at all. And we're going to talk about all the other motions and arguments that were made, and how Alan Jackson at one point said, "Save the drama for your mama." Make sure you hit the like button. Let's get to it. So we came out right at the beginning of the hearing, and we got our answer. The answer that we've been waiting for, the question that's been unanswered: will Alan Jackson continue on this defense team? Will there be severe sanctions? Will there be a situation where Judge Cannone kicks one or multiple lawyers off the defense team and says, Yannetti, you can handle this on your own? No Betterow, no Jackson, maybe no Little, because she's affiliated with Jackson and wrote and signed a bunch of the pleadings that are involved here. So we're going to start off with that. Take a listen to what the judge said, and then we'll get into how it affects this case.
Or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr.
Whoops, that was right at the end of it. Let me jump back to the beginning. That's my bad.
So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Lessie on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
So that's like a soft way of saying it, right? That's kind of a softer way. We've seen judges and heard judges say that before. Nothing too surprising there. It's like, come on, guys, let's get it together is how she could end it. But she goes so much further.
I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses.
Repeated misrepresentations that were deliberate. So it's like accidental. Was it negligent? That's what they were kind of arguing, and they fixed it. She said, no. These were deliberate. You did them in order to mislead the court and prosecution. That's what it means. Multiple deliberate lies have been told.
They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page.
The record is clear, she said, right? So you guys know from the beginning, and this has been my position the whole time. They did pay ARCCA. They made statements that would make you think they didn't pay ARCCA. They explained why they believed that what they said was still true. There was a lot of situations like when she said at sidebar, at open hearings, during trial, in pleadings, all the ways she said, it's like, I'm not so sure. But I do think that there was the record that she read and the timeline that she read was problematic for the defense to say that was incorrect. You guys fixed it. I'm going to find that there was a misrepresentation, that it was a negligent misrepresentation. I'm not going to boot anybody off. That's kind of what I expected it to go. That's kind of how I feel like that's the worst lashing it should have been. But she took it so many steps further than that, which again, to me, if you're going to take it there, if you're going to take it there and give that lashing, then do something about it. Do something about it. If this is what you feel, if you think that this happened and the record is clear, it's not a close call, right? The record is clear. Multiple deliberate misrepresentations, lying to the court, then do something about it if that's actually something that you believe.
Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation.
And that was another prong. It has to be material. It can't just be like, Judge, I wore a blue suit yesterday, but it was actually a gray suit, right? Technically, you're lying to the court. You shouldn't lie to the court. Technically, it was deliberate. You shouldn't deliberately do that. But if it's something that's immaterial, then it really doesn't matter. She is finding that this is material.
And that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations.
And she adds even more colorful language, a flagrant violation of the Rule 14 discovery obligations.
And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
All right, so I'm going to jump past this sidebar, and Brisby says only the prosecution's allowed to lie, and there's a lot of questions in the chat about what about the prosecution, what about what they did? The prosecution's supposed to be held to a higher standard. The prejudice that came from this misrepresentation that was corrected, by the way, by the defense. They could have, and this is kind of the Commonwealth's argument, they could have kept hiding it if they wanted to, right? They could have kept trying to hide stuff. They didn't. They turned it over before trial 2, before the discovery deadline closed. I can't tell you how many times I've had a opposing counsel say, we've complied with discovery, judge, just to have them turn over more discovery later. It happens all the time. It happens pretty much exactly the way the defense team explained it. We didn't know this existed. We found it existed in our email. We shouldn't have done it that way, judge. Here it is. We turned it over, and the judge will be like, please be more careful. Please don't say things that are technically wrong. Please make sure everything you say is true. I've had judges say that in cases to opposing counsel before, and we've dealt with that before. But to go this harsh and to be this over the top with it, as Judge Cannone was, to me, this all pointed towards removing Alan Jackson potentially from this defense team. The actual sanction that would hurt, the actual sanction that a lawyer would deserve if you really thought they were deliberately and continuously lying to you about material evidence. And I'm highlighting this so much because I don't know if she actually believes it. Because if she actually believed it, how could you allow a lawyer from another state to continue to practice in front of you if they're deliberately, intentionally, and repeatedly lying about material evidence? How can you trust anything they say? How can you let them make an argument to the jury? I don't understand that, because here's her answer. Here's her order.
Including a fair and impartial jury, constitutional. All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record.
So before they get to who's lead counsel, Michael, this is basically what she's saying. She's saying this was so bad, but I'm not going to take it out on Karen Reed. That's basically what she said. But let me explain to you how I see this, and if I was a judge, how I would see it. If I thought a lawyer did that to me in my courtroom and I was a judge, I'm sorry, but Ms. Client or Mr. Client, that's too bad. You picked a lawyer that materially lied repeatedly in open court to me at sidebar, in pleadings, and that just can't happen. That just can't happen. We can't allow that to happen. I'm sorry, you're going to have to pick another lawyer. That's how I would feel if I really felt the way that she felt, and that's what I believe to be true to my core. I think that's what I would do as a judge, and I think that would be the right thing to do. Chop Trials, I need to hear what Papa T has to say about this. So we may be, I'm not positive, we may be recording a podcast next week about all the last motions that were filed, hearings, all the stuff that has kind of been leading up here to the Karen Reed trial. That might be Monday's podcast. I'm not sure, though. I got to check my schedule. I don't have an easy recording schedule this week, so it'll all depend. It was definitely weird, the language she used, but no sanctions, right? She didn't fine him. I would also say, pay me $5,000, right? Not me, but you're fined $5,000. I want this to hurt because you better stop doing this. Not just here in Boston, but in California and anywhere else you practice. You better stop doing this if I believe that's what happened and I was the judge. Let's listen to the end here, and then we'll kind of talk about what Karen Reed thinks, what lawyers think, like Alan Jackson, about this, and how it's going to affect trial 2.
The record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti...
And you don't have to. Most people call Jackson lead counsel, but you don't have to, and they're saying they don't define it like that.
...is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my...
So at the end, she gave a little wink, wink, and tip to the Commonwealth. I will allow a full cross-examination. It's like, why would you not allow a full cross-examination? Is there I would stand up as defense. If I wouldn't actually do this, but if I want to be sarcastic, like, Judge, is there a witness that we're not allowed to fully cross-examine? It's like, that was weird, but it's almost like a little tip, like, go in hard at the bias, go in hard at the payment. And I think she's going to let him. I think she's going to try to make this look as dirty as possible. She's going to try to make him look like hired guns by the defense. She's going to allow, I should say, the Commonwealth to try and do that. I think that is what she's going to do. I think that's what that little tip of the cap was. What curative instruction? Like, nothing has come before this jury to say that ARCCA wasn't paid by the defense. And that's kind of the issue I take. So 2 questions here I want to get to. She threw the defense a bone. Why hate on her for that if you're also pro defense? So I would not say I'm pro anything but justice. That's what I would say. And people can laugh at that and say whatever they want. I do not think this is throwing the defense a bone. That's my point. I don't think this is throwing the defense a bone. I think she is going to say, basically, if I have to reference this later, it's because I can't believe anything you say, defense team, because I found these flagrant violations in the past. Or I'm going to give the Commonwealth the benefit of the doubt. I'm going to give them some leeway because you've been misleading in the past. Do you agree with Bev's finding? So I agree with the overall ruling and order that ARCCA is going to come in and the defense can stay on the case. Do I agree with her findings? No, I do not believe, from what I've seen of the record, that there have been repeated, deliberate, flagrant, material misrepresentations made to the court. I don't. I believe there has been an immaterial, inadvertent misrepresentation made to the court. And part of that is people hate on me for this from both sides. I take people at their word, right? I take lawyers at their word. People can call lawyers liars. They say this lawyer lied, that lawyer lied, whatever it is. If you're going to file it, you're going to say it under oath. I'm usually going to believe, unless there's very objective, and that's what I think you have to do here. Unless there's objective evidence that proves to you they lied intentionally, I think you have to see it as inadvertent. And in this case, they testified and told you under oath in open court it was inadvertent. They didn't know. And the reason I think it was immaterial, not because I don't think it's important. We talked about the fact that I think this is important. I think this is evidence of bias. I think it needs to come in. So I think that the evidence is important, but I think the misrepresentation is immaterial because there's no prejudice. The Commonwealth has the information. During the first trial, everything that was said was true. So there was no prejudice during the first trial. And I don't believe there's any prejudice during the second trial, because when ARCCA takes the stand, they're going to say the defense paid me however many thousands of dollars. And they're going to break it down. This was prep time. This was for voir dire, whatever. They can break it down however they want, but there's no prejudice. I don't see the materiality in the prejudice here for any misrepresentations that may have been made, whether intentionally or inadvertently. That's how I see what happened. That's how I see what happened. And some people can say I'm taking this too nonchalantly. This happens in cases. I have cases where people tell me something doesn't exist, and then all of a sudden it comes up later. And I make a very big deal about it. I'm like, Judge, they told me they gave me, I make a big deal about it. I'm not saying I don't. But this is not the first time that a piece of discovery was not turned over until later on in the process, but still before the discovery deadline. Hey, guess what? Everybody keep an eye and ear on this case. You want to bet something new is going to come out after the discovery deadline? It happens in every trial we cover. In every trial we watch, more evidence comes out, even after the discovery deadline. It's not how it should be. I hate it. It pisses me off, makes it harder to prep for cases, but it happens. It happens. It's not a flagrant, intentional misrepresentation. So what do I think about Karen Reed? What does she think about this? I don't think she really cares. At the end of the day, I think she's focused on her defense and winning this trial. And I think she wants the defense team to stay intact, and it's going to stay intact. So I think at the end of the day, she says, okay, it is what it is. But what do I think the lawyers think about this? I think they absolutely hate it. I think it boils their blood down to the core, because now you have a judge on the record in black and white here, in living color, I guess I should say, saying that you are a liar to the court, that you misrepresent things, that you cannot be trusted. And now, as we've seen with Spyro and Busby and all these big time lawyers, Taco Pina said it. He stated it as well. Once a lawyer gets reprimanded publicly, and you're a high profile lawyer, and you have these highly contested cases, and you like to get in there in the mud and fight as well, this can be brought up and used against you. Judge, we think he's lying here. And I'm quoting an order from the Commonwealth where Judge Cannone said he flagrantly, deliberately, and repeatedly made misrepresentations to the court. We think he's doing that again here too, Judge. And you can't say stuff like the ASAP Rocky prosecutor's like, I've never been accused of this stuff. I've never been accused of this stuff before. Well, now it's tough to say that. And if you do say that, and they respond with this to say, yes, you have. And not just accused, but a judge has found it to be that. So I don't think the lawyers are happy about this. I think they're pissed. I would be pissed. I would be so annoyed. I'd be like, Judge, look at all the discovery violations over there. They've violated my client's rights. They didn't turn over this. They didn't turn over that. No chain of custody. They're just coming up with a chain of custody now. Why couldn't Lally have done that before? That's a discovery violation. Lally said he couldn't do it, yet Brennan's doing it. Lally said he couldn't find this, yet Brennan found it. Those are intentional discovery violations by the Commonwealth. Maybe not Brennan, but the Commonwealth team. And then, of course, the things that Brennan said that he admits are just wrong. Was it intentional? Was it not? Was it material? Was it deliberate? Was it repeated? All questions for the judge. But I would be really pissed if I was the defense team and a judge said that on the record. Question. She did remove AJ. Oh, say she did remove AJ. Would that have been a claim later for appeal? 100%. Absolutely would have been a huge appellate issue. Again, if you're the defense, you don't want to get to the appellate issue. But yes, that would have been a huge issue on appeal. Okay. Let's now jump to... Actually, I'm just going to kind of explain some of these motions because we read a lot of these motions together. Alessi on the motion to exclude the Commonwealth's Dr. Wolf. Same arguments. He didn't have the right methodology or experience to do this. Brennan response. Alessi's mistaken. He does. He's a neurosurgeon, not a neurologist. He can determine how injuries are caused. I tend to agree with that. I have neurosurgeons do that. Neurospine surgeons, orthopedic spine surgeons do that in my case. Talk about causation, how an injury happened. So I tend to agree with Brennan there. But Alessi's response, I thought was good because he hammers and destroys Brennan on, he says, once again, he didn't talk methodology, Judge, which he's right. And poor Alessi, I feel bad for him sometimes because that guy pounds the law, right? He pounds the law, Judge Cannone. And Brennan gets up and is just like, this is an expert judge. He's a neurosurgeon. You know how that's a brain surgeon. You know how people say this isn't brain surgery? Well, that's what this guy does. He's so smart, Judge. And so far, Judge Cannone's just gone along with that and let all the experts in. So Brennan doesn't touch the stickier issues like methodology potentially, even though that is the standard. But lastly, Alessi, I thought, makes a good argument that causation is one thing. Manner is different. So cause and manner of death, two different things. He's not a pathologist. And to talk about cause, I really do think he can talk about cause. I think he would be he would satisfy that prong. Personally, just me speaking, I'm not a judge. But manner of death, I don't understand how he would ever be able to testify to manner of death. So I hope she blocks that. I don't know if she will or not, but we'll see. All right, next. Motion for them to use certain chalk or exhibits, demonstrative aids with the glass and different things. The defense wants the jury to be able to take it back with them in evidence. I don't see that happening. I think they're both, and Brennan even agreed, they're both going to want to use chalk or demonstratives or aids for the jury during presentation of the evidence, during the trial, during questioning of witnesses. But I don't think that I don't think the jury's going to be able to take any of this back into the jury room with them. Yeah, I see people arguing about Wolf. I think the defense is wrong that he can't testify about causation of injury. It's just my opinion. And he's going to testify about the brain injury, hitting from the back, first punch in the face, stuff like that. But I don't think it's that destructive to the defense personally either, even if he does testify to what he's going to testify to, partially, obviously, if he's a Commonwealth witness. But motion limiting about the victim's state of mind hearsay statement. So a lot of this has to do with the Aruba stuff, right? Which was a big part of that first trial. Well, Brennan gets up and says, we're not going to use Aruba. Wasn't that interesting? So the Commonwealth is not even going to try to bring in the Aruba incident. So how are they going to prove any negative intentions by Karen Reed? Is the Commonwealth going to drop count 1? Are they going to drop any negative intentions for Karen Reed and just go with an accidental death? I don't know. I thought that was interesting because without Aruba, I mean, Aruba was grasping at straws, in my opinion, to prove that, a month later or whatever, she was still so mad that she wanted to end his life. I mean, that's a pretty big jump. But to say that they're not going to talk about it at all in their case in chief, he said they may bring it up in rebuttal if they need to, and maybe that's his strategy. And if they're going to bring it up in rebuttal, so be it. But in order to prove intention during your case in chief, you have to prove it beyond reasonable doubt. So I don't know. Motion for view. This I thought was interesting. Brennan is okay with viewing the house and the car. He's okay. It seemed like he was okay with Reed being there, but more importantly, the judge seemed okay with Reed being there. So they've got to figure out logistics. They're going to propose things to the judge. The big objection that's still outstanding is Brennan does not want the car to be at the house during the view because it could confuse the jury or make them think that this is the right dimensions or whatever. And the view is different. The weather is different. The context is different than it was the day this happened. And I was like, I don't know about that. It's like Brennan doesn't want them to see how big or small the car is with representation to the yard, or would somebody be able to see this big vehicle outside that window? If they saw the vehicle, would they be able to see the body? To me, that all seems relevant. And of course, it's not snowing. Of course, it's not dark outside when they go and do the jury view. And you know how you can solve this very easily with a jury instruction to say, members of the jury, you're going to go see the car, you're going to go see the house. This is what this is not for. You are not supposed to assume that the same view here on this clear summer day is the same as it was during the winter days or what you see on the video. The weather is obviously different. The context is different. The time is different. The sun is different. But this is just so you can see the house, see the yard, see the car all in one place. Logistically, it makes it easier. You give them an instruction like that, they understand. But I think seeing the difference in the dimensions is really important. And if we're going to do a jury view, I don't know why we wouldn't want to do it right like that. All right. Next is the motion to exclude certain witnesses before and after their testimony, before, during, and after. Little basically explained Albert and McCabe's shouldn't be allowed to sit there during closing, sitting with the O'Keefe family. At least one juror told Vanity Fair they felt intimidated. The judge was really focused on one section, which I thought was telling. She basically said, after the evidence closed, are we not going to allow them to sit there for closing argument? So to me, she kind of agrees that before and during their testimony, that's easy. Rule of sequestration, they're not going to be in there. After testimony, usually witnesses are allowed to come watch. But it sounds like she is willing to entertain removing those witnesses even after they testify. But closing argument is really where she focused the back and forth between Brennan and Ms. Little. Judge Cannone said that obviously should never be used in a motion when it's not obvious, which I thought was just another unnecessary dig at the defense. So I'm not one to nitpick. I'm not one, a lot of people talk about spelling errors, punctuation errors in different people's motions, which is fine. You guys can go ahead and do that. We're lawyers. We should be held to that standard. I get it. I have typos, I'm sure, in a motion. At some point, I'm sure I've had a grammatical error in a motion before as well. But Judge Cannone even pointing this stuff out to the defense, to me, again, not a good look for an unbiased judge. You're a judge that's supposed to be unbiased there, but she did it. And then Hank Brennan gets up, and multiple times he has used his platform and his podium to say, to set the stage and the tone for the media and people watching. And this is another one where he says, which I have never heard a lawyer say this before. I'll have to ask my dad if he disagrees. The time-honored tradition of witnesses to come watch closing arguments? Like what? How many fact witnesses just show up to watch closing arguments? If you're very connected with the victims, the family, very friendly with them, fine. That's all fine. And if that's what they would have said, that they're there to support the victims of the family, they're very close to them, I think that's the better argument. But a time-honored tradition for witnesses to come sit through closing, let's take a listen to Brennan's argument here.
And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to? I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense.
He is right that generally that is allowed. Generally, it's allowed. I have never heard a lawyer say it's a time-honored tradition.
Tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert. They invoke those names. They characterize third-party culprit. And they suggest that some anonymous person was uncomfortable. It seems as though...
Oh, sorry. The anonymous person that was uncomfortable, a.k.a. a juror. Judge Cannone did ask Miss Little if the juror was a deliberating juror. And of course she doesn't know, and that'll be used against the defense that they don't know if that was a deliberating juror or not. But to me, that's pretty good for the defense, that she is considering what jurors said and maybe considering even more what deliberating jurors said. And we know that at least some of the deliberating jurors are coming out and speaking. So overall, I think that's a good indication for Cannone. I hope she is listening to what the jurors said, because that is important. And some judges would rightfully say, legally, I'm not going to consider that.
The presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion.
Couldn't agree more. Offer grace. Be a gracious person and lawyer. I couldn't agree more. And let's have Hank Brennan tell us how gracious Hank Brennan is.
Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rest and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may, or even if they do become witnesses.
So I think he's right about the family, and I think the judge will allow them to sit in there. I also think he's right that generally speaking, witnesses can sit in there for closing. And in order to remove them and not allow them to sit in there for closing, the judge is going to have to make a finding of why. Why, in the interest of justice, should those witnesses not be able to sit in there? The same reason she removed Turtle Boy last trial, because the witness intimidation and the, whatever orders were in place that would not allow them to be in certain distances from each other, or whatever it was, whatever the reason was that she said protective orders, that he was not allowed to be in the courtroom while they're testifying. Obviously, he can be within a certain amount of feet of them and those different things because he is there. They're both there in the same hearings. But there was a reason. There was a finding that she made to remove him from the courtroom. So if she is going to remove them from the courtroom for closing arguments, I think she's going to have to make some kind of finding. And we'll see what that finding is. And if she grants this, will the Commonwealth then do the same thing with some of the defense's witnesses, like the aforementioned Turtle Boy potentially? Both sides want to have a panel discussion with the jury. The judge basically says no, just because of the publicity in this case. She also talks about the recent interviews and documentaries and things that came out, which are affecting her rulings and her processes and her procedures, which I find very interesting. Chris Kay said, if we do a jury view, is the clerk of court coming? Well, it's not going to be Miss Becky. I don't know. I don't know how they do it in Massachusetts. Rebecca said, I kind of agree with the Commonwealth not wanting the vehicle there. There, I said it. That's fine. I don't care if somebody agrees with them or disagrees with me. Why? Tell me why. I always like to know why. Why do you think it's prejudicial or not a good idea to have the vehicle parked there? What difference does it make if they look at the vehicle in a garage versus look at it parked on the street there in front of the house? Even if they park it on the other end of the street, just logistically speaking, having to drive everywhere, including Karen Reed, her defense counsel, prosecutors, the judge, the jury, whoever's all going to go on this viewing, to driving them to multiple locations is also so difficult. So I would like to know why you feel that way. That the why is always the most important to me. Where you end up is what it is, right? And that's fine with me. I like disagreement, as everybody knows. Both sides agree we're going to prohibit lawyers from talking to witnesses while they're still on the stand. All right, here's the big one. The motion in limine to exclude the harassment/intimidation evidence. He starts out by saying no third party speaks for Ms. Reed or the defense. He says they don't condone any vile acts described if they occurred the way that they're described. Any of the negative things or the horrible things that have been done in this case, that's not done because Karen Reed or the defense said to. They don't condone it. They're not with that. That is not what they want, and it should not be attributed to them. And now we're going to listen to a big chunk of Jackson's argument, and then we're going to listen to a chunk of Brennan's argument as well here on this point. This was the most important or most interesting back and forth to me today.
Both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote.
And he's right. And that's the problem. And that's why I said it could actually backfire on the defense. A lot of people thought it'd be good for the defense to bring that out. She pointed the finger at the defense as if they were the one harassing her. It was incredibly prejudicial. At the time, it felt that way. It was not good. I didn't feel like the defense loved that it was out there. Some people, online felt like it was so great for them and Jackson destroyed her on it. But to me, that's not a good thing. It shouldn't come in. This should be an easy granting of this motion, but there's so much more coming. And there's still so much more drama to come with this argument.
Well, that was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it. In some way, shape, form, or fashion, she outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
Okay, isn't that rich? Isn't that rich? Now all of a sudden, the grand jury's no big deal. Just because the grand jury didn't indict or didn't come down and find that Miss Reed was involved in this harassment, that's a different standard. For a judge that they say that is rich when the judges and the prosecutors and Mr. Michael Morrissey, if we remember back to his little video that he made, basically saying, since the grand jury said Karen Reed did it, that means she did it, which is in fact not the case. But the other way is usually true. If they don't indict or if they say there's not enough here, then there's clearly not enough there to prove that she had anything to do with that. And that, to me, the fact that Judge Cannone jumped so hard at that was a very bad move, a very bad look, not something she should have done. She should have just let him make his argument. You don't need to argue with him there as a judge. That is a misstep. That is an ouch. That is a cringe-worthy moment, because for her to act like a grand jury not indicting somebody doesn't matter is crazy in the legal world, because we all know you can indict a ham sandwich, right? Well, apparently, even this was not enough to indict Karen Reed with the grand jury on the witness intimidation charges. And because we have that information, to state it as fact on the stand is troubling. It's a collateral issue. It's prejudicial. It should never come in. And guess what? Judge Cannone already argued in the first trial it wasn't going to come in. She's going to argue in this trial as well that it's not going to come in. So why argue with Alan Jackson on this point? I just don't get it.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was.
So again, he took that a little bit far. He was a little hyperbolic. I don't know that a grand jury says there's nothing to see here. There's absolutely no evidence, no connection here. I don't know that they necessarily said that. Okay. I don't know that they went that far, but to not indict does mean something. Okay. It does mean something. To act like it doesn't is not genuine.
Was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't.
So Brianna said, isn't Turtle Boy facing prison time? So this is the exact reason why it's so important that the grand jury did not find that Karen Reed was also involved. Because I think, Brianna, this was probably said in a way that you're saying Turtle Boy did something wrong because he's accused of these heinous actions and crimes, and that's what's going up against him, because those are the charges against him. But they weren't even able to bring the charges against Karen Reed. Nothing's been proven on Turtle Boy. He is presumed innocent, like any other criminal defendant waiting trial. But because there's enough to connect and charge him, people start running with it. So to act like the other side holds no weight is, I don't love stuff like that. Anything that I think is just disingenuous or that people say that they don't even believe, I have to call it out. I struggle with it. It's one of my pet peeves. Now, I don't know what somebody believes. I don't know what somebody thinks, right? We make assumptions. We learn from context clues and whatever else they say. It sure is interesting.
Didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issue?
You said when or where?
When?
I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So
this was another part of this hearing where I was like, wait, what? I remember. I got to go back and find it. One of you guys probably already found it. And if you did, send it to me on X or Instagram. But I happen to remember him asking McCabe, like, did you talk to the Alberts, Higgins, whatever, the people at the house? Did you talk to the witnesses or the people at the house? You guys have continued to talk about this case, right? They're trying to prove, right? The defense is asking questions, and the reason for their questions is the relevance is everybody's talking. Let's pin it on the girl. She looks like she did it. You know, whatever the conversations, the text messages are between all the witnesses, maybe even with some cops, they're clearly trying to just show that they're all talking to each other. They're continuing to talk to each other years later. That's the point of where Jackson's questioning was going, if I remember correctly at the time. And then McCabe said, we talk about the harassment. The horrible harassment. And then she goes into the harassment. There was a big discussion. Is the door open? Are we going to let him get into it? Are we not going to let him get into it? And the judge says the door's been open. So then boom, then we talk about it. That's how I remember it. So yes, it did come during the defense's questioning, but that does not mean the defense opened the door, which what Jackson really wants here and what Brennan's not even disagreeing with is some clarity. Can we get some clarification about what do I need to say or not say to make sure I don't cross the line? What instructions can we give to a witness to make sure that we work together in not crossing the line? And once again, this is not abnormal. In almost every case I have, every trial I have, we've got to tell a witness you can't talk about this because it's irrelevant. The rules of evidence don't allow you to. It's hearsay. Whatever the answer is, we can't talk about insurance. Every witness I put on the stand wants to be like, talk about their car insurance. I'm like, you cannot talk about insurance. It's true. It exists. We still can't talk about it. We saw in like the ASAP Rocky or Young Thug trials, like different witnesses had different criminal convictions. Sometimes you can't talk about it. And if they bring it up, it's a big no-no. And you're like, no, you can't talk about that. Could be true that they have a criminal conviction. You still can't talk about it. So instruct the witnesses what you can say, what you can't say. And if you're not sure, ask for a timeout and let's clarify with the judge. That's what you should be able to do. And if you have a witness that's willing to be fair and honest and do that, you can do it. If you have a witness that's going to force their way down a certain road, I think he says something like the door was greased open or something like that. Like you were going to make sure it was going to be open. And when Hank Brennan makes his argument, he says, I'm pretty sure the defense is going to open the door again. If everybody knows it's going that way, why don't we do what we can to stop it from opening the door since we all agree this is a collateral issue that's prejudicial?
The court did make that ruling that ultimately if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event.
Or watch it, because I'm sure it's going to be all over Twitter now tonight. And I'm sure Alan Jackson is going to see exactly that part of the testimony. Anybody that posts it, don't edit it too much, right? Leave it open so there's no even appearance of impropriety or somebody say, oh, you edited it to look like that. I'm always uber cautious of that these days because everybody can call anything AI or edited or whatever it may be, but just be careful. Show the whole context of the clip. If I'm wrong, I'm wrong. That's just how I remember it. This was a long time ago. It was a year ago, right? That's just how I remember it. And I could be wrong. I'm not going to swear under oath that my exact version of how I explained it was how it was explained. So I didn't watch the documentary. I think I'm not going to watch it before the trial. If the trial gets continued from April 1st, then maybe, but I don't think I'm going to watch it before the trial.
I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed, and the information.
So Mo, you can't tell those witnesses that they feel they're wrong, they want to be heard. There's an opportunity for them to be heard, right? And it's going to be during the Turtle Boy witness intimidation trial. That's where that information is relevant. Because they tried and could not connect Karen Reed, that makes it wholly irrelevant to this trial. And I have had to tell clients, listen, I know this really sucks. Like, they think, I've got some clients that think, you know, what happened in this trucking accident caused them to lose their job. Sometimes that's true. Sometimes we can prove it. Sometimes we can't prove it. And if we can't prove it and the judge doesn't let us argue it, whatever it may be, there's a lot of legalese and it depends and different things that happen. Let's just say that's something they truly believe it with all their heart, that that is part of their damages. And I have to tell them, we're not going to go into it. You were paid under the table, whatever the reason was, right? Just because somebody thinks, they were wronged and they want to be heard doesn't mean that every platform or opportunity they get is the appropriate time for it. If a crime was committed and the state is proving that at trial, they will have their opportunity to testify. But it is not during the Karen Reed trial. And the judge agrees and the prosecutor agrees, by the way. What I'm saying is not rocket science. Or controversial, I should say.
Information came in, but it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time.
And that's usually how you tell a lawyer not to open the door. It's like, don't ask, were you ever intimidated? Don't ask if you feel harassed or if you're nervous to be here. Don't ask those types of questions. But to ask, like, do you talk to other witnesses about the case and them to immediately go to that? That's not appropriate because you got to be able to ask about their conversations with other witnesses in the case.
What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. And in the event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another, walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
They would open the door. I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me,
Here we go. Set the stage, set the mood. Lights, camera, action. And both of these lawyers, both teams, they really have taken their moments a lot during the first trial. We said it about the defense team as well. Lally did not do it as much, but Brennan is like, he uses these hyperbolic words all the time, right? Grossly, flagrantly. That was the judge. But here we go. And he's about to go into how grossly misrepresentative this was of the truth. He's going to reference things he knows. By the way, Judge Cannone is not the only judge that doesn't like the outside publicity. Most judges don't like documentaries and interviews and, going on YouTube channels or whatever. Most judges don't like that. And most lawyers know that. So he's playing into what the judge doesn't like as well when he references the documentary. Let's get this answer real quick. Rebecca said the why is because you cannot duplicate the exact conditions unless they're viewing it at night in the dark and in the snow, but you don't have to. Like almost every jury view of all time is not in the exact conditions or circumstances as when the crime was committed or the incident happened. So that's not the standard for a jury view. It's not. So knowing that that's not the standard for the jury view, that's why I would think that it should be there, personally, logistically, if nothing else.
Beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard.
And again, a lot of this finger is pointed at Turtle Boy.
About the tactics.
And again, I see a lot of people talking in the chat like they'd be better off without Turtle Boy or they're better with Turtle Boy. Here's what I'll say about Turtle Boy. He has talked about this case a lot. He has gotten a lot of eyes and ears on this case. He has gone on other shows. He's gone on, like, I think even like mainstream media, potentially different kinds of platform, getting this case out there, getting people know about this case. His actions have also created at least the allegations of this witness intimidation and harassment. That is a negative to this situation and this team, but Karen Reed has not been charged with anything. So they are not relevant to her trial. They should not come in with her trial. So I think it's important to understand that getting all the eyes and ears and attention on this case that he has, and the positives, probably some negatives to that too, versus the accusations being made in the separate charges, everybody's going to have their opinion about Turtle Boy. I do not think, this is just my opinion, and this is how I feel as well. I do not think your opinion of Turtle Boy should affect how you view this case in Karen Reed. I think if he made you look at this case, great. Take a look at it, see what you think. I think if you love Turtle Boy, I think you should still look at this case with an open mind to determine what do you think the evidence proves? What does the investigation prove? If you hold them to beyond a reasonable doubt, can they prove the case? If you hate Turtle Boy's guts, I still hope that you would look at this case, and I think he would want you to just look at this case with an open mind. Is this case proven beyond a reasonable doubt? What does the evidence say? What do the cops say? Because somebody outside, whether they're a jerk, whether they're nice, whether they're a genius, whether they're an idiot, I've probably been called all those things, maybe not a genius. It doesn't really matter what people on the outside say. You have a brain, you have eyes, you have ears. Look at it, listen, review, learn the legal standards and principles, and determine what you think the outcome should be. And if you think there are major problems to stand up against them respectfully, gracefully, peacefully, but stand up and say something when you see something that's wrong. You're not going to agree with what everybody else thinks is wrong, right? What I think is wrong, you might not think is wrong, and vice versa, and that's okay. Don't hammer somebody because they don't see it exactly the way you do. You don't get anywhere doing that. Frankly, you probably turn more people off. You turn people away from good causes more than you could bring them towards a good cause. I don't know why. We get off on all these tangents all the time, but I just feel like it is important to understand that it's not a monolith. Not everything's a monolith. Not everything is just one way. And in America, with the two-party system, sometimes we fall into that if you're on this side, you got to believe all this. If you're on that side, you got to believe all this. I've never been accustomed to that. I think more people shouldn't be. I think there's a lot of nuance in what we think and believe and say. Like this, Sue. This is really helpful, Sue. So I'm sorry. Based on what I just said, I just have to do this. I don't like doing this, but please stop with the titles on your streams. Okay, I'll stop putting titles on my streams. They are wrong. I disagree. I think the judge's words for the defense were incredibly harsh. And if I was a defense lawyer, I'd be pissed about them. Okay, so I disagree. And a lot of times I ask questions that are asked to me as the titles to my streams. It's like, I try to get what we're going to be talking about. I mean, whatever. It's so perfect, right? I should just put Karen Reed as the title to every one of my streams. It's just, it is what it is, right? It is what it is with this stuff. It's just, that's a funny example of how stuff works and how the world works and what's not helpful versus what is helpful. If you don't like the title, guess what? You never have to read it again. Don't look at it. All right, here we go.
Used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand.
Fraudulent. The record he made was grossly inept and fraudulent. This is one of those times I think he's just like on a roll speaking, because that doesn't make sense to me.
And the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. Yeah, we'll be prepared.
And see, that's the problem. So he is now saying, and if I was Alan Jackson, I'd be writing this down. It looks like he is writing. That's funny. Brennan just said, if they make these baseless attacks and allegations and this whole third-party culprit, or that something happened in the house, right? Which we all know they're going to do some version of that. They're going to do some version of, it looks like he was beat up. Maybe this happened inside. Maybe it didn't. They didn't investigate these people. These people have relationships with the cops. These people were talking to each other, right? So if Hank Brennan is saying that that line of questioning and that argument is going to open the door to the harassment, I think he's dead wrong. And if I'm Alan Jackson, I want clarity on that. Judge, is he saying that he thinks that, because are you saying, Judge, more importantly than what Brennan's saying, are you saying the door is open if we make these arguments? It can't be. But if they talk about harassment, intimidation, has anybody said anything to you, or what's happening on the outside is so bad? Fine, that's opening the door. But they do need some serious clarification on what is going to open the door and what's not. Because what Brennan just described sounded like he was saying this is going to open the door. Does not seem like it should open the door.
I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
1 second.
Where this ire,
All right, go ahead, Mr.
I
Jackson.
just wonder if
So here's Jackson's response.
where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make.
So I think he has before, right? He has attacked witnesses. He has bashed witnesses before. He even said, like, I got all I needed out of Jen McCabe during the trial, right? But definitely not right there. He definitely didn't bash or attack a witness right there. So he's right. It's like, what was Hank Brennan listening to the same thing we were all listening to?
Didn't make any fraudulent statements. The Commonwealth made their best effort to tether Ms. Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said. At the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say,
That is true. Probable cause is basically the lowest. I would say maybe if you want to take it to a level of like reasonable suspicion that cops have to do certain things. But yeah, probable cause is like as low as it gets, and they couldn't even do it there. So to act like it's a fact and to act like it's a fraudulent misrepresentation, to say that it's not true when you couldn't even get a grand jury to agree with you, that just misses the mark. Like, I don't get it. I don't get it. Should Karen Reed have had outside counsel during her discussion with the judge? Potentially, I think that she was already instructed to potentially talk about this with outside counsel before. Sometimes when they discuss like Yannetti is potentially outside counsel because he's not included in this, but he's part of the team. So there's ways to do it. I would think that she has talked to outside counsel about it before answering the judge today. Does any of Brennan's rhetoric towards the defense seem like there's something personal with him? I don't know. I think if anything, if I had to guess, it was like he thinks this is his opportunity to really be, the guy, to be him, and that's the only feeling I get. I don't think it's anything personal. I don't know. I don't know what the relationships are like. I would love to know one day, hook somebody up to Truth Serum and ask them how the heck Brennan ended up here.
I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. And so, sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of. And they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan.
He frankly gave her credit, right? He said that stuff is vile. That stuff is despicable if it happened the way that she did, which is like exactly what we've said on this channel for I don't know how many years we've been talking about this case. So I said, I don't know if I've ever agreed with Alan Jackson so much. The outside noise, the intimidation, the horrible things, if that's true, if that's happening, that's horrible. Everybody should condemn it. That should be easy to condemn. But it's not relevant to this case or this trial.
Brennan's tone and tenor, we can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking.
I agree. Calm the drama down and we'll get a little bit further. And you know what? This brings me back to the very beginning, full circle moment, right? To the very beginning of this hearing. The judge's comments to the defense counsel and what she thinks of them sometimes emboldens prosecutors to also go at defense counsel. Like, Judge, same. We're on the same page with these liars over here. They are fraudulently misrepresenting stuff to the court, to you, to the public. Same, Judge. That's kind of the vibe it can set and the tone it can set, which can also be dangerous. And if you're not going to kick somebody off a case to make the comments she did, can do further damage in the future of the case and can, really give Hank Brennan, especially with the whole like a full cross-examination, you give him some leeway to maybe say some things he wouldn't say in a normal professional environment in front of a judge that maybe didn't feel that way. So there's going to be an overtone now of this case since those comments were made. Only to one side.
Asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance. Before I ask a specific question that I think comes anywhere close to that, we'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
Okay. The next couple of things are the extrapolation. They need more information, the criminal history of certain witnesses. The Commonwealth agrees it's not coming in. Then they do a motion to continue. And Jackson says the defense is ready to go. So it's not like the first trial's motion to continue, but a significant appeal in the First Circuit. The Commonwealth gets up. Basically, they agree that with the defense's arguments that could create issues, but they don't want to move the trial. And it seems like they're going to talk more and get back to the judge, see if they can get a better timeline about when we're going to get an answer. The briefing is going to be quick, but when the judge is actually going to give an answer, we're not so sure. Will this case get continued? I don't know. Lastly, Brennan thinks the case is going to last 3.5 weeks, which is shorter, I think, than the Commonwealth's case in chief last time. And the defense said 1.5 to 2 weeks. So that puts us in the 5 to 6 week range for the trial. We know they're not going to do full days. They're going to take a break here, a break there. So it's going to probably take longer than that. But we have some information as far as that goes as well. Going back to Bev scolding AJ, isn't it more likely than not Brennan misspoke, Bev flipped, and then she had to save face, hence the tongue lashing. Most judges wouldn't do that. Like, it's been months. It's kind of, people aren't talking about it as much. You can just be like, I find a discovery violation. She could even say something like this. I find a discovery violation. I don't like the way it looks, Mr. Jackson, but there's not enough evidence to find that it was intentional. So at this point, I'm going to give you the benefit of the doubt. You better not do anything close to that again, which she basically says you better not do anything like that again. That's how I would have done it if I felt kind of on the fence about it, unlike her, who seems like she thinks he just intentionally, repeatedly does this stuff. I don't know how you let him keep practicing. What's your line for bias necessitating a new judge? The Young Thug trial. Go take a look at that. Go take a look at that. I don't think judge could, I don't know about the conflicts and people saying other things she has. I don't know that background, how she has acted, even though I think some of her rulings have been pretty horrible. I don't think she has crossed the line of bias to where an appellate court or a higher court would make her recuse herself or throw her off this case. Did you see they let Judge Gold stay on the case? That's another line that I think was crossed. Martha, Peter, it's your thing. Do what you want to do. They can't tell you who to sock it to. Yeah, you know, it's funny. Like, the people that are the loudest about, you better not do this, or I'm out because you did X, Y, and Z, or you let somebody do X, Y, and Z, are asking me to do exactly the thing that they don't want me to do, right? Like, I try to really listen to as many people as I can. I think it makes me smarter. I think it makes me better at what I'm doing. It makes me see arguments from all sides. You may not like how somebody argues or talks or whatever. But like Turtle Boy, for instance, I don't know him personally. I've never really spoken to him outside. I think like a DM on social media, potentially about, hey, do you have this, or do you want this? Because I heard you're going to talk about that or whatever. Sure. Yeah. Thanks for sending me that. I'll talk about it, whatever it may be. And anybody that does talk to him or have him on or talk about him at the case, I don't condemn them, right? I want to try to focus as much on the Karen Reed case as I can. And I know if I had Turtle Boy on, how many different ways the conversation would go. And I want to keep it to the Karen Reed case. I want to talk about the Karen Reed case. I want to bring it all the way through. The witness intimidation case, even as the judge and the Commonwealth agrees, is not relevant, should not come in the Karen Reed trial. He has never said, actually, I don't know. I don't know what he said on his channel or about me. I've heard he said some bad things. I've heard he said some good things. But he's not going to tell me what to do or to say or to think. I think he knows that. I think deep down, whether he says it or not, he probably respects that. And he's like, he's going to look at the case how he sees it. I hope he sees it the same way as I see it, which I understand. Anybody that sees a case a certain way, it's like, hey, I hope this person sees it the same way I do. But if they don't, I get it. Maybe he wouldn't get it. I don't know. But nobody here is doing anything based on what any other channel, any other person. Let's talk about Emily Baker. Emily Baker covers this channel, right? I've had Emily Baker on. I've been on her channel before. I think we've talked about this case. We've talked about a lot of different cases. I'm not going to change something that I say because of what she says or what she thinks. And I know darn sure she's not going to because of what I say or what I think. And that's how it should be. And that's what makes it great. That's what makes YouTube great. You can go and listen to who you want to listen to about what you want to listen to about. Rebecca said, I default to you, Peter. I'm just an ER nurse paramedic. Thank you. You're always honest, sending love from North Dakota. And Rebecca is one that we disagree all the time, respectfully. And it's cool and it's fun and we learn from each other. And sometimes I'm like, yeah, I actually see it that way, especially when she talks about what the EMS people are saying or what they're seeing or, you know, what you would do in this situation. Because I've never been doing taking life-saving measures medically for somebody. And then legally speaking, I like hearing from jurors, and she could be a juror in her jurisdiction. Sometimes I'll disagree. Sometimes I disagree with jurors. They make the ultimate decision though. Sometimes that's what makes this great. And what makes it fun is there's people on all sides of the spectrum. Now, there are some people that absolutely make it not fun, and I get it if you think any individual person is that. I've come across plenty on Twitter. But they don't have to affect your life, right? You can just ignore them. They don't have to affect your life. They try, and that's what they really want, but just keep on keeping on, right? And just try to learn. Try to get better. Try to see what we can do in these cases and talk to different people. I actually encourage you to listen to people you don't agree with sometimes. I think that's fun. I like listening to people I don't agree with. I really do. I can't find a ton of lawyers that see a lot of this differently, but if you do have some, let me know. I find it interesting. All right, I got to go here. Chris said, he wrote this early on. Peter, off topic, please cover the hyperbaric chamber explosion and charges brought in Michigan. You got to send me more on that. I don't know anything about it. I'll take a look at it if I can, but honestly, we got Vallow, we got Koberger, we got Reed, we got Adelson, we got so much stuff popping off right now. Azam, congrats on more than 459 subs. Thanks for all you do, Peter. Keep being you. I ride or die for your channel. Love from Malaysia. I never worry about that, Azam. And speaking of somebody, if they disagree with me, if Azam disagrees with me, I got to check it once, twice, and 3 times, right? Because she asks a lot of questions like, why do you say it like this? Or why do you say it like that? Or what does this mean? And it's fun. That's what makes it fun. Cool. Learning. Okay. I got to run. We're going to a Charlotte Hornets basketball game tonight. We're excited about that. If anybody's going to be there, hit me up on social media. Maybe I'll see you around whatever their stadium is called. But I appreciate everybody joining me. Make sure you're subscribed. Yeah, we're working our way towards 500,000 subscribers. It'll be so awesome if we ever get there. So thank you. Tell your friends following this case or other cases to come subscribe, and we will continue talking about it. But I appreciate you guys so much. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.